Hello everyone, my name is Ben Wells and I'm a partner at CANDEY, a litigation law boutique firm located in Lincoln's Inn in London. I'm also the chairman and founder of RusFor, a group created for Russian-speaking lawyers. And we've enjoyed events in many countries, including in London in the Shard, to Minsk, Moscow, and also just before the pandemic at conferences in Almaty and Baku. It's really fantastic to be able to draw people together from a diverse geographical base, and that's definitely the case today as we bring together specialists from jurisdictions from the USA to China and touching many countries in between, as well as attendees from worldwide. It's certainly one of the best things about the digital age, which I'm sure we will go on to appreciate for a long time to come. I'll now pass over to Jan, who will introduce RAA40.
Thank you very much, Ben, and I thank RusFor for joining forces with RAA40 to prepare and broadcast this webinar, or I would even call it an online conference, given the widespread panel of stellar speakers. So RAA40, as many of you know, is an organization in Russia for young arbitration practitioners. So we try to network and inspire young lawyers to do arbitration, to find out more about arbitration and various interesting issues around it. So basically, that's why we are also organizing various events now, including online events like this one. And now pass over to you, Ben, for actually starting the event.
Thank you, Jan. Today we're going to be talking about the relationship between bankruptcy and international arbitration, which is more important than ever. Many companies and individuals continue to face financial hardship and the threat of insolvency due to the ongoing challenges of the pandemic, and with more and more commercial disputes being referred to arbitration, not least thanks to recent favorable developments in Russia, such as the ICC and FIAC recently being recognized as permanent arbitral institutions. With both insolvency and arbitration on the rise, it's inevitable that there are clashes between them. In my own practice at CANDEY, I've dealt with matters where one party finds they cannot commence proceedings because the other party has become insolvent. Very often, it can be a race against time to institute proceedings. Before starting my presentation, I'd like to introduce my fellow speakers in the order in which they will appear. Each speaker, by the way, has roughly 10 minutes to tell about their own jurisdiction before moving on to any questions that you may have, which you can enter into the Q&A function. Firstly, Dr. Alexander Shchavelev is a senior associate at Pinsent Masons. He was born and raised in Russia before moving to Germany. He's German qualified, a PhD in law and Masters of Law, and his work is very much split between litigation and arbitration, with a particular focus on Russia and other former Soviet Union countries. George Utlik is in Herrick's Restructuring and Finance Litigation Department. George focuses on domestic bankruptcy and cross-border insolvency, as well as international judgment enforcement and commercial litigation. Born and raised in Belarus, George is a native Russian speaker and often asked to assist with matters which involve the Russian Federation, Commonwealth of Independent States, Ukraine, and other Baltic states. Oliver Loksa is counsel at Hausmaninger, Kletter in Vienna. Thanks to his multicultural background, he developed an interest in international dispute resolution. He regularly advises clients in cross-border, white-collar crime proceedings and international commercial arbitration, especially in Eastern Europe. In addition, he's a member of various international and national legal associations in the fields of criminal law and arbitration, and he continues to regularly lecture and publish on pertinent issues. Cassandra Gimbert is an associate in the Mergers and Acquisitions Department at Sagasser in Paris. She's recently been involved in structuring fundraising and setting up management packages, and thanks to her Franco-American background, as well as her interest in business and tax law, she intervenes in legal and tax structuring of group companies with French, European, or American clients. Charles Tay is foreign legal counsel at Zhong law firm in Beijing. where it's a band 1 red circle law firm in China with well over 1,000 lawyers. He focuses on international arbitration, having previously worked in Singapore and London, and his experiences straddle both the East and the West. Jan Kalish is a counsel and advocate at Rybalkin, Gortsunyan and Partnery. Jan focuses on international litigation and arbitration of high-value cross-border disputes. He represents clients before arbitral tribunals, acting under various rules of institutions, including ITC, FTC, LCIA, and others. He also holds a PhD in political science and is co-chair of the Arbitration Association 40, RAA40, and a member of the Chartered Institute of Arbitrators, ICC Russian Commission, and International Arbitration Steering Committees. So my presentation is going to specifically focus on a discussion of the laws in England and Wales. I'm going to look at the issues from this perspective, and as an outline, the key provisions are the Insolvency Act 1986, the Corporate Insolvency and Governance Act 2020, and the EU Regulation on Insolvency Proceedings, which is part of the retained EU law in the UK, as well as the UNSTRAL model on cross-border insolvency. I'm going to focus predominantly on the provisions of the Insolvency Act 1986 as subsequently amended, and consider the effect of insolvency on arbitral proceedings in English law and what parties can do when insolvency and arbitration clash. Before considering the effect of insolvency on arbitral proceedings, I want to note an important practical step that a claimant may take as part of arbitral proceedings against a respondent who's faced with immediate insolvency. Since there's a real risk that a respondent may dissipate their assets prior to that insolvency, the court, arbitral tribunal, or emergency arbitrator may grant a wide range of urgent temporary relief against those parties, such as freezing orders, for example. This is a familiar territory. However, it's really noteworthy that in the context of arbitration, the court may be unwilling to act where a party has the option of seeking interim relief from, for example, an emergency arbitrator or from a tribunal, or if the arbitration agreement is silent on the issue of interim relief. Authority for this is seen in Gerald Metals and Timmis, where the court dismissed an application for emergency relief as it held that effective relief was potentially available already under the LCIA arbitration rules. Under the Insolvency Act 1986, there's an automatic moratorium comes into force once a company goes into administration. This means that no legal process, including, as you can see on the slide, legal proceedings, execution, distress, and diligence, may be instituted or continued against the company or property of the company, except in certain circumstances. So, for example, with the consent of the administrator, or as discussed earlier, with permission of the court. Arbitration very much falls under something termed as legal process. So while an administrator has the power to commence arbitration in the name of a company, claims may only be commenced or continued against that company with the consent of the administrator or permission of the courts. A similar moratorium exists with respect to compulsory liquidation, following an important recent development through the Corporate and Insolvency Governance Act 2020. A company may apply for a moratorium so that it remains under the control of its directors, subject to the supervision of a monitor, to explore potential rescue and restructuring options. The purpose of the moratorium is to give the company some breathing space during a period of financial difficulty. In contrast to companies in administration or compulsory liquidation, an automatic moratorium does not apply to members' voluntary liquidation or creditors' voluntary liquidation. However, the court has a discretion to order a stay in relation to particular proceedings upon the application of the party, and that's in accordance with section 112 of the Insolvency Act 1986. So this still does remain a possibility through the court. It follows from the Insolvency Act that it's difficult to commence or continue arbitration when a respondent becomes insolvent. There are, however, three ways in which it's possible. Firstly, the claimant can obtain the consent of the administrator or permission from the courts. When deciding whether or not to grant permission, the court will balance legitimate interests of the applicant along with the other creditors, as was seen in the case of Re-Atlantic Computer Systems PLC. It's also important to remember that the limitation period continues to run during the moratorium, and the court will take into account an impending limitation when deciding whether to grant permission to bring any claim. Secondly, the arbitration can continue elsewhere. It's worth remembering that arbitrators are not generally bound by the determinations of national courts outside the seat of arbitration. So even if the national court has ordered a stay or an automatic stay has come into force, the arbitrators may continue proceedings elsewhere. This was an issue in Susca Electrim against Vivendi Universal, when the court held arbitrational proceedings could occur in parallel to insolvency. Thirdly, an insolvent party may also be substituted by another party in the arbitral proceedings. This depends very much on the facts and the legal circumstances, but in the case of A and B in 2016, that's the legal authority where this was made possible. In that case, the High Court upheld the arbitral tribunal's decision to substitute one claimant. Now, that was after the original party merged with another company and finally ceased to exist. And since the other company had legally assumed the original party's obligations under the contract, that contained the arbitration agreement. Under Article 5(2)A of the New York Convention, the recognition and enforcement of an arbitral award may be refused if the subject matter of the difference is not capable of settlement under the arbitration law of that country. In the English case law, an arbitral award is considered an unsecured debt that runs pari passu with all unsecured debtors, and so a party may not bring individual enforcement proceedings against a party subject to English or compulsory liquidation or administration. That's all in accordance with the Insolvency Act. A good case study is the case of Riverrock Securities against the International Bank of St. Petersburg, which I don't know whether Jan might touch upon in his talk later as well. This is a High Court judgment from England they handed down in last November. The court granted an anti-suit injunction, which restrained proceedings that had been brought in breach of an arbitration agreement in Russia by the liquidator of an insolvent company, and so affirms that claims arising out of insolvency must be arbitrated where the arbitration is broad enough in its wording to cover such claims. It held that in circumstances in which the claims sought relief, which the tribunal was able to grant, and did not engage the interests of third parties, those claims were arbitrable. In particular, there was no sufficient countervailing public policy considerations at play, arising from the fact that claims were avoidance claims in a foreign bankruptcy in order to override the clear policy of English law of upholding arbitrations. To conclude on the English law part, Riverrock is really a fitting example of the English court grappling with the clash between insolvency and arbitration, deciding as a matter of construction that the LCIA arbitration agreement covered the insolvency claims brought in Russia. The case very much affirms the pro-arbitration stance of the English courts. For all the difficulties insolvency poses, it should not always get in the way of the parties agreeing in their arbitration clauses. So while through the moratorium on proceedings, English law does seek to protect companies that are going through insolvency from further legal claims, the scope for parties to continue the proceedings with the court's permission demonstrates some limited flexibility as the court seeks to balance the legitimate interests of the applicant along with other creditors. I'm now going to pass over to Alexander.
Thank you, Ben. And thank you, Ben and Jan, for inviting me to speak here and to present the German perspective. In the first step, I'm going to introduce to you the very basic principles of German insolvency law. And the first is that the insolvency administrator takes over control over the insolvent company after a petition for insolvency has been filed. The petition can be filed either by the company or by its creditors. And there is an insolvency register in Germany where you can search for the respective company's name and see if insolvency petition has been filed or the stage of the proceedings. Once the petition is filed, a preliminary administrator is appointed, who, however, has the control over the party, and usually the preliminary administrator is the administrator throughout the whole process. There are other proceedings aiming at restructuring the companies, but I can't go into the details of that due to the time constraints we have today. The main goal of the insolvency administrator is to keep together the assets of the insolvent company and try to get as much as he can into the insolvency estate in order to satisfy the company's creditors, who are treated equally. That's one of the basics. Of course, there are special rules for preferred or secured creditors, but amongst the respective class of creditors, everybody is treated equally. For that purpose, of course, no individual enforcement of claims is possible once insolvency proceeding have started. Instead, each creditor, irrespective of his position and claim, has to register his or her claim with the claim schedule, which is then validated by the insolvency administrator in a specific process. If the claim is considered valid, then it is simply put onto the claim schedule, and the creditor just have to wait until the insolvency is over. However, the administrator and the fellow creditors can contest registered claims. And if this is the case, then the respective claim has to be litigated or arbitrated, depending on the chosen dispute resolution mechanism. In order to keep the insolvency estate together and to get as much as he can into the estate, the insolvency administrator has specific rights and can take specific measures to do that. For example, if a contract has not yet been fully performed, the insolvency administrator has the choice whether he elects performance or suspension of the contract. And there is nothing the counterparty can do about that. In addition, there are various means of recourse against detrimental transactions that took place prior to filing for insolvency. Most of the basic principles of German insolvency law are considered to be part of the ordre public, and so the public policy, particularly the rules that ensure the equal treatment of creditors and the specific rights of the insolvency administrator that he has. So what happens if the insolvent party is party to an arbitration? Well, in insolvent German party, well, there is no distinction between claimant and respondent. So independently, is it an active action of the party, or is the party or the respondent, the same rule apply? There is also no vis attractiva concursus, which means that there is no exclusive jurisdiction of the insolvency court. The only exception is the insolvency specific rights and measures of the insolvency administrator. These are not subject to the chosen dispute resolution mechanism. However, of course, the administrator can agree to arbitrate. To show an example is the right of the insolvency administrator to choose performance or non-performance of contract in itself is not arbitrable. However, if the insolvency administrator chooses to perform or continue performance of the contract, then any dispute arising out of such performance would be subject to the agreed mechanism, thus arbitration. As I said, the insolvency administrator is bound by the arbitration agreement that was concluded by the insolvent party. The only exception to that rule is that the insolvency estate is insufficient to cover the costs of the arbitration. So the costs, the advances that had to be paid to the institution, for example. In this case, the arbitration agreement is deemed to be incapable of being performed under German law. This, however, doesn't mean that no arbitration proceedings are possible at all. The creditors may agree to fund the arbitration, for example, if it is an arbitration in which the insolvency administrator or the company is the creditor. Or the insolvency administrator can make use of third-party funding, which is quite often the case in Germany. As I said, you have to register your claim to the claim schedule in order to be taken into account in the distribution of the assets. Hence, if you haven't commenced an arbitration yet, you have to register your claim before continuing. If the arbitration is already running and then the respondent filed for insolvency, then you have to register the claim before continuing. Once the claim is registered, the insolvency administrator can decide whether to contest the claim or not. If he contests, then of course you have to start arbitration or continue the pending arbitration. The right to contest a claim is also provided for the fellow creditors. So they can, well, look, guys, there's someone registering 100 million claim. I don't think it's a valid one, so I don't want to share the proceeds of the insolvency with that guy, so I contest the claim. For that claim, because there is no arbitration agreement between the fellow creditor and the other one, the claim cannot be arbitrated and has to go to the state court. So potentially there is a risk that the claim against the company has to be arbitrated twice if contested by administrator and creditor. A rather formal issue is that the insolvency administrator not only takes over control, but is considered to be the new party in the arbitration. So if you have continuing arbitration, then you have to file a request for change of party and amend your prayers for relief. An exception applies for self-administration, where the insolvent company remains the original party but is subject to approval by the insolvency administrator. Because your claims cannot be enforced individually, you have to register the claim. You have to change the prayer for relief in the arbitration to the insolvency specific relief, which is basically a declaratory award by the arbitral tribunal that the claim is to be included into the claim schedule. So that was the perspective from an insolvent German party in arbitration. What happens if you have a Germany-seated arbitration, but an insolvent party abroad? We have to differentiate between EU and non-EU cases. In the EU, the insolvency regulation applies if insolvency proceedings are instituted in an EU member state. If there is no pending arbitration, then the decisive law is the law of the insolvency proceedings. However, if the arbitration is already pending, then the lex arbitri decides over what happens to the arbitration. And that, according to German view, includes the arbitrability and the continuity of the arbitration agreement, which may be a different outcome under the two laws. However, it has to be noted that there is no settled case law and that this is only a predominant view in academic writing. If we have a party that becomes insolvent from non-EU country, then the foreign insolvency proceedings are, as a rule, recognized. However, there is a notable exception. that the German courts, or Germany said, under German law, a lack of jurisdiction of the foreign insolvency court, which may pose a particular problem with respect to the center of main interest. In particular, if insolvency proceedings are initiated with respect to a group of companies abroad, and companies from various jurisdictions are included into that petition. So what are the effects of an insolvency brought onto a German state arbitration? Well, once, and that might be surprising, there is no automatic stay of arbitration. The German law simply doesn't have a respective provision. There is such provision for litigation, but not for arbitration. However, the arbitral tribunal is usually going to use its discretion and temporarily stay the arbitration for two reasons. First, to ensure the insolvency administrator's right to be heard and due process, and to allow the claimant to register his claims. If the arbitration continues, then the insolvency administrator is bound by the state of the proceedings. So what do you do if you have an award? Well, that's quite simple. Award creditor, as Ben said on the English law, in Germany is not a preferred or secured creditor. It's an ordinary claim. If you have an award before insolvency was filed, you have to register your claim, and you can expect that the underlying claim is rather unlikely to be contested. However, you have to go through the enforcement proceedings in Germany. A post-insolvency award, again, you have to register your claim and potentially enforce it. However, because it was issued post-insolvency with the participation of the insolvency administrator, that is rather a straightforward issue. And with that, I will conclude my presentation and pass over the Atlantic to George.
Thank you, Alexander. Greetings from New York. My name is George Utlik. I am counsel at Herrick Feinstein, a law firm that is based in New York City. Thank you for inviting me to speak on this panel. Today, I will discuss the impact of insolvency and domestic and foreign arbitration, providing a U.S. perspective on this relevant topic. Next slide, please. The economic hardships brought about by the COVID-19 pandemic have impacted many companies globally. Many people agree that once the government's financial aid stops, we will see an increase in restructurings due to the impact of the pandemic. Companies that have arbitration clauses in their commercial agreements should consider the impact of insolvency on pending and future arbitrations. Under US law, by the way, a debtor does not need to be insolvent in order to file for bankruptcy protection. So when I use the term insolvency, I basically mean that a company has some liquidity issues or it's unable to pay its debt as they come due. And therefore, the company may choose to seek protection under the US Bankruptcy Code to liquidate its assets or to restructure its business affairs. It's important to note that upon commencement of a bankruptcy case, the automatic stay under Section 362 of the Bankruptcy Code applies to the commencement and continuation of all civil proceedings, and that includes claims and counterclaims brought in arbitration. Bankruptcy courts have discretion to issue orders to enjoin arbitration proceedings. And an arbitration award that is issued in contravention of the automatic stay may be declared void and vacated, or it could be denied enforcement by courts in the United States. Therefore, it is very important for anyone involved in arbitration to actually consider whether to seek permission from the bankruptcy court to proceed with the arbitration. Historically, US bankruptcy courts have opposed to use the arbitration to resolve disputes. Nowadays, and the recent trend is for US bankruptcy courts to actually accept arbitration as a proper forum for dispute resolution. I must point out that arbitration law in the United States does not contain any statutory provisions that specifically govern the effects of a bankruptcy filing. So the governing law is basically the US Bankruptcy Code, and US courts simply aim to reconcile the purpose and the effect of the Bankruptcy Code with the purpose and the effect of the Federal Arbitration Act. The common issue addressed by bankruptcy courts is therefore whether there's any conflict between the Federal Arbitration Act and the Bankruptcy Code. Is there a conflict between the Federal Arbitration Act and the Bankruptcy Code? Well, the Bankruptcy Code favors centralization of claims against the debtor in one forum, that is the bankruptcy court. The Bankruptcy Code provides that claims against the debtor and its property should be determined in the bankruptcy proceedings, with only a few exceptions. All of the property of the debtor is basically an estate property, and it's centralized in the bankruptcy case under the jurisdiction of the bankruptcy court. The automatic stay prevents litigation from progressing in any other forum during bankruptcy, so that all creditors are treated equally. On the other hand, the Federal Arbitration Act favors arbitration agreements. It is binding on both federal and state courts and promotes a decentralized approach towards dispute resolution to reduce costs and delay of litigation. Mandatory arbitration provisions, in fact, threaten the bankruptcy court's power to adjudicate disputes regarding the debtor and the bankruptcy estate. Proceedings with arbitration in a non-bankruptcy forum sometimes may reduce the value of the estate to the detriment of all other creditors. Therefore, US bankruptcy courts may find that arbitration sometimes conflicts with the purposes of the Bankruptcy Code. And these purposes include the goal of centralized resolution of primary bankruptcy issues and the need to protect creditors and debtor from piecemeal litigation. A party to an arbitration with a debtor should consider to seek the bankruptcy court's authorization to proceed with arbitration. Even if the debtor started the arbitration and is willing to proceed, a creditor nonetheless should apply to the bankruptcy court with a motion to lift the automatic stay and to compel arbitration to avoid future disputes over the enforceability of the arbitration award against the debtor. Bankruptcy courts evaluating motions to compel arbitration usually exercise their discretion and conduct a four-part test as to whether the parties agree to the arbitration, whether the dispute falls within the arbitration clause, whether the claims involve core or non-core bankruptcy issues, and whether the court should stay any non-arbitral claims pending the outcome of the arbitration. The issue that is most often litigated and decided by the bankruptcy courts is whether the claims that are being arbitrated are core or non-core. As a general matter, core bankruptcy matters include those that arise under the Bankruptcy Code and those that arise in a bankruptcy case, such as confirmation of a plan or adjudication of claims. Core bankruptcy matters are likely to be resolved in the bankruptcy court as a general matter. Non-core matters, on the other hand, and these are those claims that arise outside of bankruptcy but are related to a bankruptcy case, are more likely to be resolved in arbitration. When in doubt, it's best to consider contacting a US law firm to discuss the issues and to develop a strategy how to best proceed. Next slide, please. Some practical considerations for US courts often exercise their discretion in support of international arbitrations. In fact, arbitration is favored in the international context. And some of the considerations are international comity and respect by US courts for transnational tribunals, as well as the sensitivity to the needs of international commercial system. Filing a proof of claim in the US case does not waive an agreement to arbitrate. Even if you file a proof of claim, you can, as a next step, go to the bankruptcy court and file a motion to seek the bankruptcy court lift the automatic stay in order to proceed with arbitration. Again, as a general matter, bankruptcy code's priority of payment provisions apply regardless of whether the dispute is resolved through arbitration or litigation before the bankruptcy court. So, for example, unsecured claims are still entitled to receive a pro rata share of any distributions out of the bankruptcy case. As to insolvency proceedings that are commenced outside of the United States, automatic stay of arbitration or litigation is possible only if the foreign insolvency is recognized in the US under Chapter 15 of the Bankruptcy Code. The last point I'd like to make is that any company that is considering an arbitration should evaluate the laws of multiple jurisdictions. And that includes the seat of the arbitration, the place of bankruptcy, as well as all those countries in which enforcement of an award may be thought. And that's why this panel is relevant and important. Thank you. Now I will pass it to the next speaker.
Thank you very much. Thank you very much, everybody. Thank you very much, Ben and Jan, for having me to speak on this highly relevant and interesting topic, which for sure will not leave us in the upcoming months and years. I'm happy to provide you with some perspective under the Austrian law on bankruptcy versus international arbitration. And fortunately, there have already been, especially under German law, there has a lot already been said, which I can refer to. So my program, in short, I will give you some basic overview on the basic principles on bankruptcy proceedings under Austrian law, and then I will immediately move on to the pertinent issues which have arisen under Austrian law and have been dealt with by the Supreme Court. They have not always been very conclusive statements by the Supreme Court, and then I will leave you with some short conclusions. So, as under obviously most jurisdictions, there are various forms of insolvency proceedings. One, of course, is the bankruptcy proceeding itself, which we are focusing on here today. And then there are restructuring proceedings, which can be undertaken under self-administration or under the administration of an administrator. The latter, obviously, plan or the intention of the latter is to keep the company working, whereas bankruptcy proceedings aim to liquidate assets and to basically wind up the company. Now, what are the requirements? That is probably pretty straightforward in a theoretical way: illiquidity and over-indebtedness of the company. And in order for the proceedings to start, there has to be sufficient assets to cover the costs of the proceedings, at least to initiate the proceedings. That might sound harsh or might sound a lot, but in essence, 4,000 euros are sufficient for the proceedings to start. One highly important aspect which I need to point out, although it is not directly related to our topic today, is management liability, according to which, if the requirements of bankruptcy are being met 60 days after the requirements are met, the management has to file a respective filing. Then we have, of course, those basic principles which especially Alexander already pointed out, and which will accompany us when I talk about Supreme Court decisions, which is claims being contested by either the administrator or a creditor. And we'll get to that shortly. So what happens if there's a pending arbitration and suddenly a company goes bankrupt, respondent goes bankrupt mostly? So this obviously presupposes the question, what does it mean if arbitration is pending? And this was dealt with in a Supreme Court decision not so long ago, a couple of years ago. But let me first point out the theoretical aspects. Pending presupposes a first procedural step in arbitration, obviously. Now, the question is, what is the first procedural step? If we have institutional arbitration, that is rather straightforward because most institutions in their arbitration rules have included a clause according to which, receipt of the request of arbitration, the arbitration is considered commenced. That is obviously a bit more difficult to judge or to assess if we have ad hoc arbitration without rules. Usually there is, again, of course, a notice of arbitration or even a statement of claim. What has to be taken into consideration, though, is that such notice or statement of claim has to be sufficiently specific. So one has to be able to derive from that filing which claim is being claimed, what are the facts of the case in order for an arbitration to be considered pending. Now, in the Austrian Supreme Court decision, very often talked about Supreme Court decision of a couple of years ago, the question was whether a request to have an arbitrator appointed constitutes such a first procedural step. The arbitration clause essentially said that if there is a disagreement between the parties appoint an arbitrator, respondent failed to do so, the two parties have to appoint one arbitrator. The respondent failed to do so, which is why claimant requested the appointment of an arbitrator, and then the respondent went bankrupt. The question now was whether such a request of an arbitrator appointed already suffices for arbitration to be pending, and the Supreme Court affirmed such stance. It said that the request of an arbitrator appointed cannot be seen as a separate step. It is connected to the arbitration already. Now, and if we have a pending arbitration, and if we have bankruptcy, then suspension of the arbitration proceedings arises. So I understand that this is different than in German law. In Austria, under Austrian law, we have an automatic suspension, even if it's arbitral proceedings which are about to be suspended. The question, obviously, if we have suspension, is what happens and when and where can arbitration continue? This is, in Austria, we call it the Prüfungsprozess, so it's a declaratory action, whether claims by a creditor are valid, and this can be contested, again, as I understand, similar to under German law, especially both by the administrator and the creditor itself. By the creditor itself. So the Supreme Court differentiated between these two acts, or these two entities or persons, differentiated between a creditor and the administrator. If arbitration is pending, mind we are here already under the circumstances of a pending arbitration. If arbitration is pending and the claim is disputed by the administrator and debtor, which go hand in hand, obviously, then the arbitral proceedings continue as Prüfungsprozess, as declaratory action. So the creditor has to has to follow his suit in arbitration, or is entitled to follow his suit in arbitration. The other question, the second question, is what happens if the claim is disputed by a different creditor? If we have 100 creditors and one creditor disputes the claim of a different creditor. Now, this has not been dealt with exhaustively by the Supreme Court. This has been left open because there was simply no reason to rule on such a situation, because in the case I mentioned, only the administrator contested the claim of a creditor. And please keep in mind that the Supreme Court did not see any problem with the extension of the binding effect of an award on other creditors if the person contesting a claim is the administrator. So the Supreme Court did not rule on the consequences if a creditor contests a claim. There are views in favor of a binding effect of the arbitral agreement, of the arbitration agreement, on creditors who have not signed the agreement, and there are views in literature against it. On the slide, you can see basically the basic arguments. One being that awards and state court judgments are being deemed equivalent, and therefore there should not be a difference whether the creditor is follows his claim in arbitration or in state court proceedings. The other argument was, which seems a bit misleading or weird when written down, is the lack of specific rights of creditors. What the Supreme Court meant with that is that basically the effect of a creditor contesting a claim might lead to other creditors receiving a bigger quota of the assets. So it is not a specific right of the creditor. These views have again supporters and enemies. Basically the arguments against such view mirror the arguments in favor of such view. One big one, obviously, is that creditors are not parties to the arbitration agreement. Especially Austria is rather hesitant when extending arbitration agreements to non-signatories. So this is certainly an argument that has to be taken very serious. And then the other argument, and that mirrors, as I said, the lack of the specific rights of creditors, is that, well, creditors have a right to contest a claim. It is written in the law, and it is too easy to simply say that it's not a specific right. It just leads to a bigger quota. So that is the counter argument. So these issues have been left open, and it will be interesting to see when and how the Supreme Court deals with them. And this already actually brings me to the conclusion section of my presentation. I think what can be derived from the Supreme Court decisions and from the Austrian perspective is that when it comes to insolvency proceedings, it is the view is rather arbitration friendly, which is not always the case in Austria, but in this case it is. One big issue also being, and the Supreme Court specifically stated that the arbitration proceedings which have already commenced and were pending and then suspended should not be lost. One should not need to initiate new proceedings and from the scratch, basically. So I think that is a very practical and also very favorable stance. What remains to be decided, as I said, is the question how to deal with creditors, with the binding effect of an arbitration agreement on creditors who contest a claim from other creditors. Thank you very much. And I pass on to my colleague Cassandra, who will provide her view on this very interesting topic. Thanks.
Thank you very much, Oliver. I want to thank you, Jan and Ben, for that invitation and the opportunity they offer me. So I'm just going to share my screen right now. So I'm going to present the French aspect of the confrontation between bankruptcy and international arbitration. Just to present briefly myself, I'm an associate in Paris in the international law firm of Sagasser, Selas. And I'm currently specialized in corporate tax and M&A. So just to introduce my presentation, in France, as soon as a company is in difficulty with a risk of cessation of payment, we speak of mechanism of collective insolvency proceeding, referred in my presentation as bankruptcy or insolvency proceeding. Bankruptcy is a procedure that places a company in difficulty under judicial control to organize the settlement of its claim. It brings together all the creditors and deprives them of the right to act individually. There is 3 types of proceeding in France, depending on the seriousness of the company situation: safeguard proceeding, judicial recovery proceeding, and judicial liquidation proceeding. Bankruptcy defends collective interest as the safeguarding of the company and the protection of the creditors. However, these objectives are not the priority objective of arbitration, thus creating a significant gap between those two concepts. Indeed, arbitration aims to protect the interest of the party to contracts. In other words, it protects individual and private interests, not taking into account the mass of creditors of the company concerned. Even if arbitration clauses are not rendered ineffective by the mere fact that one of the parties is subject to bankruptcy, arbitration will have to respect the mandatory provisions specific to insolvency proceeding. On the other hand, the judge commissioner will have to apply the principle of arbitral jurisdiction when they have to deal with contractual issues that are not part of the essence of the bankruptcy regulation. My presentation of the French aspect of that confrontation will illustrate the existence of an arbitration clause has in itself repercussion on the conduct of bankruptcy proceeding, but also that the opening of a bankruptcy procedure in France has repercussion on pending arbitration proceedings or on the application itself of an arbitration clause. So firstly, in France, state courts do not have exclusive jurisdiction in situation of bankruptcy. Indeed, the French Court of Cassation has indicated in a decision dated on June 2nd, 2004, that when an arbitration proceeding is not in progress on the day of the opening judgment, the bankruptcy judge, before whom an arbitration clause is invoked, must declare himself incompetent unless the arbitration agreement is manifestly null and void or unforeseeable. However, we need to underline that as soon as there is a debate on the existence or the validity of an arbitration agreement, the unforeseeability can no longer be established, making the above report difficult to implement. Case law systematically rejects the argument that the liquidator is acting in the interest of the creditors, as this argument does not change the enforceability of the arbitration clause. As enforceable, the arbitration clause would permit the arbitrator to rule on a claim that would have arisen either in the absence of a bankruptcy, but this will be limited by the rules and the principle applicable to bankruptcy, and that's what we are going to see in the second part of this presentation. First of all, the bankruptcy has an effect on arbitration for the principle of the stay of individual proceeding. Under French law, bankruptcy is governed by the principle of the stay of individual proceeding, and the rules is as follows. The judgment opening a bankruptcy procedure prohibits individual creditor from suing the debtor. An arbitration procedure as an individual procedure will naturally be subject to this principle. Consequently, Court of Cassation have considered that an action for annulment against an arbitration award made prior to the judgment opening the collective insolvency proceeding, as well as a creditor claim before an arbitration court, fall within the scope of individual proceedings subject to the principle of the stay. A recent decision illustrates that idea. This jurisprudence concerned a request for exequatur of an arbitration award having condemned a French company to pay to a Swiss company a certain sum representing the price of the transfer of the shares. The case involved the opening of the safeguard proceeding against the French company and the voluntary liquidation of the Swiss company, which had declared the claim resulting from the award, which had been contested as a liability. While it was in amicable liquidation, the Swiss creditor company requested the exequatur of the arbitral awards and the delivery of an enforceable copy. The French Court of Cassation refused on November 12, 2020, the enforceability of the award, considering that the purpose of the exequatur could only be the recognition and enforceability in France of the award and could not, without disregarding the principle of the stay of individual proceeding, render enforceable an order to pay. The Court of Cassation also added that the exequatur order issued after the declaration of the claim resulting from the award escaped the complaint of violation of the principle of international public policy of the state of individual proceeding of the debtor by the creditors with regard to this recognition effect only. This led us to the question of public policy rules. Different rules considered as public policy have direct effect on the arbitral jurisdiction itself and the power of the arbitrator. The arbitral jurisdiction is limited because even if the arbitration clause is considered enforceable against the body of the bankruptcy proceeding when the dispute will have taken place even without the intervention of the bankruptcy, this clause appears to be inapplicable when the judicial representative initiates the specific action resulting from the bankruptcy. In other words, certain disputes cannot be submitted to an arbitrator as they fall solely within the jurisdiction of the collective insolvency proceeding judge. That's the example of the nullity of the suspect period, the debtor management power after the opening judgment, the specific liability, or again, the sanction that the law imposes on manager. Also, the power of the arbitrator is limited by, firstly, the principle of equality of creditors considered by the French Court of Cassation as a national and international public order principle, as it was illustrated in his decision of 1988. As illustrated there, in France, even if an arbitral tribunal is regularly seized to hear a dispute over a claim, it can only establish the existence of a claim against a debtor and cannot, in any case, order the debtor party to pay. Otherwise, the rule of priority between the different creditors could no longer be respected, thus breaking the equality between them. Moreover, the res judicata effect of a decision admitting a claim constitutes an obstacle to a contrary arbitral decision, which must be set aside. There is other problematic, and the big one is the lack of funding. In bankruptcy, as a company not being free anymore of its acts, only the liquidator named by the judge can act in the name of the company, and therefore only him can represent the company within the arbitration proceeding. The liquidation is often financially unable, the liquidator, is often financially unable to advance the provision of an arbitration when the arbitration clause is enforceable against him. That implies a risk of denial of justice. The Court of Cassation states that the insolvency of the party is not enough to characterize the manifest unenforceability of an arbitration agreement. In other words, the impossibility of financing an arbitration procedure is not sufficient to prevent a company from an arbitration procedure. The reason of this principle is simple, and it's the mere fact that the liquidation has been ordered does not necessarily mean that the company is not able at all to pay. There are other ways of mitigating this financing problem. For example, when the liquidator is the defendant, he can request the claimant to advance the funding so that the proceeding can take place. However, when the liquidator is the claimant, this situation could not really be possible in reality. There is also possibility to use legal protection insurance and also request a manager of a company to advance the funds when this later has an interest in the reconstitution of an asset in order to possibly avoid an action against him. Finally, there is other practical problem arising and even before the opening of the bankruptcy proceeding. Indeed, when a company is no longer able to pay the creditor, it must file a declaration of cessation of payments, as my colleague showed that in Austria we have a 60-day period. In France is a 45-day period. If it fails to do so, serious consequences await the company manager. To illustrate the difficulty links to arbitration, let's take the example of a company in real financial difficulty, which holds for a contract a claim on a third party. If a company wishes to implement an arbitration clause in the hope of recovering a claim that he holds against a third party, in order to put an end to a certain situation of cessation of payments, and by the way, escape from the bankruptcy proceeding, the practical difficulty of implementing an arbitration procedure may lead to the legal deadline of 45 days being exceeded. Arbitration cannot therefore be a solution of a situation of cessation of payment and a means of avoiding collective proceeding. Finally, regarding the European regulation mentioned by my colleague before, Alexander, I will not focus on that point because the general question raised in France are quite similar, in particular with around the definition of what is a pending proceeding. However, to conclude, arbitration clauses are enforceable in nature but limited in their scope by the rules and principles applicable to bankruptcy. The arbitration principle rule in bankruptcy is to determine and recognize the existence of a creditor or of a debt, but not to implement it. That's the problematic that creates difficulty about the interest of justice and the risk of denial of justice with, for example, the problematic of the lack of funding, as I explained before. And also the limitation on the contractual freedom of the party who just wanted to put an arbitration clause in their contract and cannot implement the clause at all or just in part within a bankruptcy proceeding. Thank you very much, and I pass on my colleague Charles.
Thanks, Cassandra. As a practitioner based in Beijing, we are now moving from the west to the east, and I will speak from the mainland Chinese perspective. For my presentation, I have 4 slides and 2 stories to tell. In mainland China, the starting point when talking about corporate bankruptcy is the enterprise bankruptcy law. There are some provisions in the enterprise bankruptcy law which can be applied to the intersection between bankruptcy and arbitration. Some of these provisions parallel some of those that have been shared by the other speakers. For example, Article 20 of the EBL, the Enterprise Bankruptcy Law, provides that after the People's Court accepts an application for bankruptcy, any civil action or arbitration involving the relevant debtor shall be suspended. Article 21 provides that after the People's Court accepts an application for bankruptcy, and the relevant debtor's civil action shall be filed with the very People's Court only. On first reading, it may appear that the effect of Articles 20 and 21 together is that upon bankruptcy, the courts should have exclusive jurisdiction over claims concerning the debtor. However, Articles 47 and 119 permit for the arbitration of creditors' rights, and there are cases in China which show how the interplay between these articles work, which I will come to in due course. Judicial interpretations assist in interpreting laws in China. These judicial interpretations are issued by the Supreme People's Court, which is the apex court of China. The 2013 Judicial Interpretation 2 of the EBL has a provision concerning the revocation of debt payments made in arbitration proceedings upon the application of a bankruptcy administrator. This is at Article 15. And Article 47 reiterates what Article 21 states, which is that after bankruptcy proceedings have commenced, all civil actions shall be under the jurisdiction of the bankruptcy court. Moving now to the 2019 SPC Provisions 3, this one has some interesting provisions. For example, Article 7 permits the revocation of legal instruments that have determined creditors' rights erroneously, or which contain or which give effect to a fabrication of creditors' rights. In such circumstances, a bankruptcy administrator is empowered to apply to the People's Court to revoke the legal instrument concerned. And it has been held in a case which that legal instruments can cover arbitration awards. However, Article 8 specifically provides that where parties have made an arbitration agreement before the commencement of bankruptcy proceedings, the parties may rely on the procedure of arbitration to confirm their debtor-creditor relationship. Cases concerning bankruptcy and arbitration in mainland China can be grouped into two sets. The first set shows an arbitration-friendly, non-interventionist approach. In these cases, the PRC courts have refused to set aside arbitral awards issued in proceedings conducted parallel with bankruptcy proceedings, and the majority of cases fall in this set. This slide sets out some of these cases. For example, in the Beijing Haiwen case, first up in this slide, this concerned parallel bankruptcy and arbitration proceedings. After bankruptcy proceedings commenced, but before the defendant company was deregistered, the company commenced arbitration at the Beijing Arbitration Commission against a contracting counterparty. The arbitration was fought to the end, but after the arbitral award was issued, the counterparty applied to set aside the award, relying on Article 21 of the EBL, which I shared earlier, which provides that after the commencement of bankruptcy proceedings, all civil actions shall be subject to the centralized jurisdiction of the bankruptcy court. The Beijing Fourth Intermediate People's Court held that from the perspective of both literal and structural interpretation, civil litigation and arbitration are two different dispute resolution mechanisms. Thus, it could not be concluded that the claim under arbitration concerning the debtor fell under the jurisdiction of the People's Court handling the bankruptcy application. The cases Shanxi Quarter and Yangtze Gui concern similar issues, and they both also held that arbitration could proceed in parallel with bankruptcy proceedings. The fourth case on this slide, Shenzhen Weixing, concerned bankruptcy proceedings that commenced while arbitration was ongoing. The plaintiff submitted that the arbitral tribunal should suspend its hearing of the case based on the enterprise bankruptcy law. However, the arbitral proceeding proceeded with its case and issued its award. The plaintiff, in setting aside proceedings, sought to argue that the arbitration was procedurally flawed and the arbitral award violated public policy. However, the court upheld the validity of the award. On this slide are some cases which are in the minority where the PRC court set aside arbitral awards because of bankruptcy proceeding related reasons. The first case, Shantong Dai, concerned bankruptcy proceedings that were commenced after the company's creditors had agreed to a court-sanctioned reorganization plan. A creditor commenced arbitration and obtained an award against the company concerning an alleged debt, which was also the subject of the reorganization plan. The validity of this arbitral award was then challenged in set-aside proceedings, and the court noted that based on some provisions of the enterprise bankruptcy law, reorganization plans approved by the court shall be binding on the debtor and all creditors. Therefore, the arbitral award, which was issued in this case, contrary to the reorganization plan, was held to be invalid, and because the debts that were within the scope of the reorganization plan were non-arbitrable. Thus, relevant portions of the award were set aside. In the second and third cases here concern similar situations where creditors obtain an arbitral award in their favor in parallel with proceedings in bankruptcy proceedings whereby they should have declared their creditors' rights. In the Jiangxi case in the middle, such arbitral awards were held to be invalid and was set aside. The third case involved an arbitration which proceeded parallel to bankruptcy proceedings, but in the arbitration, the bankruptcy administrator was not notified and did not have the chance to participate in the arbitration. And thus, the court held that this was a material procedural violation and decided to set aside the award. Moving now to my fourth and last slide, I mentioned at the start that I have two stories to tell. And these stories are stories of our cases over here at Zhong, and these concern live clients and live proceedings, and I will share what I can based on our experiences. The first story concerns a large business operating in China with foreign participation. The business is held through an offshore holding company, and on the client's behalf, we commenced international arbitration against one of the shareholders. So this was a shareholder dispute. Regarding an overlapping set of disputed facts, the opposing shareholder filed a winding up petition in the offshore jurisdiction on just and equitable grounds. We applied to have the winding up petition struck out on the basis that the shareholders' agreement provided for disputes to be arbitrated. The first instance offshore court supported our application and ordered a partial striking out. However, the opponent appealed and succeeded in reversing the jurisdiction, and therefore the winding up proceedings were reinstated. We then appealed this decision to the next level, and we are currently awaiting the final court's decision. This case shows that the intersection between bankruptcy and arbitration can be quite complicated, and that even senior judges can have very differing views on the issue. And now I'll move on to the second story, and that's another case which is also about a widespread business operating in China. In this case, the offshore holding company of our client had an arbitration agreement with a foreign counterparty, and the foreign counterparty claimed that monies were owing and directly commenced a creditor's winding up petition offshore. However, the alleged debt had issues touching on mainland Chinese and Hong Kong law, and we believe that the offshore insolvency court was not an appropriate place for the debt to be adjudicated. Thus, we commenced arbitration in Hong Kong pursuant to the parties' arbitration agreement and applied to the offshore court to have the opponent's winding up petition struck out. This was towards the start of the year, and we succeeded in this application. The offshore court in April decided to strike out the opponent's winding up petition, and it held that there was a dispute in relation to the debt, and that the proper forum for resolution of the dispute should be arbitration, as the parties had contractually agreed. In other words, it was inappropriate for the opponent to bypass the arbitration process and seek to directly wind up our client. And with these two stories, I cap off my presentation. And at the bottom of these slides, I have set out some recent cases from two other important jurisdictions in the Asia Pacific, which is Hong Kong and Singapore. And courts in these jurisdictions have in recent years turned their minds onto the intricate intersection between insolvency and arbitration proceedings. And these cases are worth considering, but I only have so much time today, and which I believe is much too short to do justice to this very interesting topic. And I hope that the cases that I've shared and my two stories have been of interest and are a useful introduction to how this topic is treated in this part of the world. And with this, I pass on now to Jan, who I believe will have many more interesting points to add from the Russian perspective. Thank you.
Thank you very much, Charles. And I want to thank the whole panel for your very interesting presentations. I will try to make my presentation at least as interesting. So just a second. Sorry. Sorry, I cannot, for some reason, start the slideshow on my screen. Maria, maybe you could help me with the presentation now. Thank you so much. So while the presentation is uploading, I guess, I just want to start with an obvious proposition that the clash between the bankruptcy and arbitration is very, very topical. And I would say that for the Russian jurisdiction, this clash is even more topical than for many other countries. Sorry, just let me try one more time. No, it doesn't work for some reason. Yeah. Yeah, so for Russia, for the Russian jurisdiction, it is even more topical. In Russia, we have had an increase of yes, thank you very much, Maria. So we have had an increase of bankruptcies so far, and we have also remained as a jurisdiction very interested in arbitration. We have many arbitration users. And our clients use arbitration all over the world and in Russia. So the clashes between arbitration and bankruptcy are basically inevitable. And that's why I've kind of chose this motto for my presentation, which is, although taken from a US case, fits very well to the point which I'm making in my presentation about Russia. In some countries, as we have seen from the presentations we've had, bankruptcy does not really fight with arbitration, but in Russia, the fight is quite fierce. Next slide, please. So starting from the general framework, as you might know, Russia is a civil law jurisdiction, and of course, both bankruptcy and arbitration are heavily regulated by law. But at the same time, of course, the parliament is not that fast, and the life is always faster, and that's why many tricky and interesting issues derive from the court practice. And we have the Supreme Court as the higher court in the Russian Federation, and the guidances of the Supreme Court and positions of the Supreme Court in specific cases are usually followed by the lower courts. That's why I will start with the general legal framework, but then go to some specific positions the Supreme Court took on in specific cases. So in Russia, we have concentration of disputes, or the vis attractiva concursus, as referred to by Alexander, I think. That means that our commercial courts, we do not have special bankruptcy courts, but our commercial courts have exclusive jurisdiction for bankruptcy matters. And it means that if the bankruptcy initiated, the general rule is that the claims should go to the bankruptcy case, so that all the creditors could raise positions about specific claims that are introduced. There are certain exceptions, of course, as always, and not all those exceptions are properly tested in practice, but such an exception as current payments, for example, salaries, or payments of tariffs or something like that, they are tested in practice, and that they can be resolved sometimes separately from the bankruptcy proceedings. However, the general rule in law is only set out for claims that are introduced in courts. And the general rule is that after the so-called monitoring stage, the claims should go to the bankruptcy case. But there is no specific legal regulation about the claims that are being arbitrated. That's why basically all the positions that I will be discussing today from concerning the clash between bankruptcy and arbitration will basically derive from the court practice. Although I have to say that the position do bear some degree of analogy with the general regulations for court claims. So, of course, in the bankruptcy we have a number of stages, but the stages that are essential for our topic today is the monitoring stage and the so-called receivership stage. In Russian, it is called konkursное производство. I think it most easily translates to English as receivership. And the basic distinction is that after monitoring stage is introduced, arbitration can still survive. After the receivership stage is introduced, arbitration may not survive at all. But firstly, before that, I have to say that the position of the bankruptcy towards arbitration very much depends on who is being bankrupted, whether we have an insolvent claimant or an insolvent respondent. And if we have an insolvent claimant, the issue is not that difficult. The insolvent claimant can still arbitrate its claims. The insolvent claimant, according to one of the recent positions of the Supreme Court, can even enter into arbitration agreement with a third party and arbitrate that claim. But in practice, there is one issue that the courts and the Supreme Court consider crucial, and the issue is access to court. As you know, of course, and appreciate, in bankruptcy, the debtor is always short of money. And arbitration is quite an expensive story. Court justice in Russia, on the other hand, is very, very cheap. Our tariffs are very low, and there is a widespread variety of lawyers with very different very different rates. So it's sometimes very easy and cheap to litigate in Russian courts. Easy, I mean, from the expenses perspective, once again. So on the other hand, arbitration may not be that cheap, especially if we have an arbitration not somewhere in Russia, but some LCI arbitration or Hong Kong arbitration. And before we entered into the new world of pandemic, every arbitration was kind of contemplating traveling, accommodation, and a variety of different costs. Today, of course, those costs can be cut via virtual hearings, but still it is an issue. So that's why if the claimant shows that he cannot enforce, and by claimant I mean the bankruptcy trustee of the claimant, that he cannot enforce the arbitration agreement because the arbitration is simply too expensive and the claimant doesn't have money for that, the Russian court may be amenable to allow the claimants to breach the arbitration agreement and go for litigation within the bankruptcy case. If we are talking about insolvent respondents, there is a number of scenarios possible, and I will show you them on the next slide. So the easiest scenario is when we have already arbitrated the claim, and we have the award, and we go for enforcement with the Russian court. And after we filed for enforcement in order to obtain the so-called enforcement writ, only then the insolvency kicks in, so to say. In this case, the applicant has a choice whether to proceed with the original enforcement case, obtain the enforcement writ, and then file the enforcement writ into the insolvency case in order to join the rank of all other creditors, or to drop the original enforcement case and introduce the award for enforcement in the bankruptcy case. So why this choice is important? The thing is that even if you have an enforcement writ from a Russian court, which you then introduce into the bankruptcy case, the creditors, according to bankruptcy legislation, still have the right to object your claim being included into the register. This is a fundamental rule of the Russian bankruptcy legislation, that all the creditors should have a say about each other creditor's claim. And that's why if you continue with the original enforcement case, you will be basically facing two cases in a row, because you will first have to obtain the enforcement writ in a court, but then you will have to go to another Russian court, or basically the same Russian court, but to another judge, and once again defend your award against other creditors. So this choice basically in practice depends on various commercial considerations. How much do you have until your enforcement action is concluded? How many other creditors are in bankruptcy? What is the value of your claim? Whether you will be the overwhelming creditor in the register and will basically rule, or you will be a minority creditor and others will be able to attack you. So that's the choice to be made. If the award is issued before the insolvency starts, and you only then go for enforcement, you can only go to the bankruptcy case for your enforcement. And once again, you will have to face objections from various creditors. I don't mean that it happens every time. Of course, your claim may be crystal clear and none of the creditors find anything at all to sort of attack, but still that is a possibility and the risk to be considered. The interesting stuff happens when you have a real clash of bankruptcy and arbitration. So your arbitration is still pending, but the insolvency against the defendant in the arbitration is commenced. So if the arbitration is pending at the moment when the monitoring stage of the bankruptcy is introduced, the arbitration can continue. So that's a good thing for an arbitration lawyer and an arbitration user. But at the same time, one have to note that at the receivership stage, it is a position of the Supreme Court, which I cannot say I totally agree to, but still, when the receivership kicks in, arbitrators lose their jurisdiction, and the case should follow to arbitration. So the monitoring stage usually takes about half a year. There may be a couple of months for other operations around the monitoring stage. So you basically have 8 or 9 months of monitoring stage to conclude your arbitration, if it is pending when the monitoring stage is introduced. So it is up to the arbitration participant to sort of reconcile and understand whether the arbitration has the chances to be concluded before the monitoring stage is ended, and to decide whether to continue arbitrating the claim or not. However, the downside of continue arbitrating is that the claimant in arbitration doesn't have any rights of a creditor in the bankruptcy proceedings. So as a contingent creditor, the arbitration claimant cannot object to other creditors' claims or cannot participate in other various steps of bankruptcy. So basically no control over how the estate is being managed at all. And of course, if the arbitration cannot be concluded until the receivership, it might be really a lost cost, because in Russia, most likely the courts will decide that the arbitration concluded after the receivership results in an award that would contradict to the public policy. I have to mention that this position does not directly follow from the law, but this is a recent case of the Supreme Court, and we of course should be mindful of that position when considering our steps towards bankruptcy and arbitration. Well, and of course, if arbitration is not commenced before insolvency, so insolvency precedes the arbitration, under Russian law and practice, the claim cannot go to arbitration. They should go to bankruptcy case directly. However, there might be a position that the exceptions that I've showed on the previous slide, the claims about exceptions can be arbitrated without those stringent limitations. But once again, unfortunately, this position is not properly tested, so we cannot rely on it. In the next slide, I would like to discuss the clashes that happen when cross-border insolvency and arbitration are in the picture. And once again, we have several scenarios here. And the first one is when insolvency proceedings are outside Russia, but the arbitration is in Russia. And what one have to note is that Russian insolvency laws do not apply automatically to Russian seated arbitration if there is a bankruptcy outside Russia which is not recognized in Russia. There is a possibility to recognize judicial acts originating from foreign bankruptcy, but if it is not done that way, there is no protection, statutory protection from Russian laws that apply. So at the same time, the tribunal sitting in Russia will probably be minded to give effect to the restrictions imposed by foreign insolvency regime, because if the arbitrators do not do that, and then the successful claimant tries to bring enforcement, bring the award to enforcement in Russia, Russian court might be respectful of the foreign insolvency and see a public policy issue if the foreign insolvency regime was not respected. And I will go to an example a little bit later. On the other hand, if we are talking about the status of the bankruptcy trustee or the receiver in Russia, the recognition of this status should not need any special recognition by courts, because basically under Russian laws, the companies are operating under their laws, under laws of their of the country of their incorporation. And if the bankruptcy trustee becomes a legal representative of the company according to the laws of the relevant country, in Russia, those powers should not be specially recognized in order to be effective on our soil. What is interesting is when insolvency proceedings are in Russia, but we have a foreign arbitration. Ben has already alluded to the Rybalkin case. I of course could not go past that interesting case. I will not spend much time elaborating on this, but in Rybalkin, the court basically decided that the arbitration that was started after the bankruptcy, that arbitration was still valid, and the arbitration agreement should have been enforced. As I've said before, Russian court's approach would probably be different now, because although there is no specific wording about that in law, the position of the Supreme Court is that the arbitration that is introduced after the insolvency should not proceed. Another interesting example I wanted to share with you and conclude is the EWUB case. In this case, we have a claimant who sued in the LCA arbitration his debtor and two guarantors for the debt. And this EWUB bank won the LCA arbitration. However, the primary debtor was in the pending bankruptcy proceedings in Austria. The guarantors were two Russian companies, and they were also subsidiaries of the debtor, but the subsidiaries were not insolvent, they were going concerns in all respects. So the claimant went to Russian court to enforce the LCA awards against the two guarantors / subsidiaries of the debtor, and the Russian court was extremely respectful of the Austrian bankruptcy, and said that since the guarantors are 100% subsidiaries of the Austrian company, which is going through insolvency proceedings, any award against those subsidiaries will basically reduce the assets of the Austrian company and violate the rights of the Austrian company's creditors. So that's how those guarantors basically escaped liability under the LCA award. The case is very interesting because for a curious and creative mind, it can even create some basis for a scheme how to escape liability, I would say, but I'm sure no one will use it that way. So that's what basically it's. As you can see, there are many interesting issues arising in Russia, and I have to say that I am, as arbitration practitioner who also practices in bankruptcy sphere, I often face opinions from true bankruptcy fans that arbitration should kneel before the bankruptcy, but we as arbitration community always resist and say that no, arbitration should be given space, notwithstanding the bankruptcy proceedings. So it's a very interesting topic, and I'm very glad that we've had an opportunity to discuss this in such a varying mode for several jurisdictions to introduce their views. Unfortunately, we have lost Ben because he is traveling right now. But on his behalf and on my own behalf and from RusFor and RAA40, I want to thank very much our panel of very interesting speakers. I want to thank all the audience who survived our long conference. And I hope you've got some insights from our talks. And if you have any questions, unfortunately, we do not have time for them now, but all of us are available by email and social networks. Please reach out, ask your questions. We will always be happy to talk them through. Thank you very much and have a great day.
Thank you. Bye.
Bye, everyone.
Thanks.
you.
Bye,
Thank
everybody.
you all. Bye-bye.
Thanks for attending.